right, so Kevin, here we have another midday breaking news readathon for you.
Oh my goodness, we'll be doing multiple times a day at this rate.
I don't think multiple times because boom goes the dynamite.
Mm-hmm. What happened?
Well, the jury came back with a note for Judge Bev Cannone, and she said it was a note unlike any other that she had ever seen a jury send to her courtroom.
Okay.
So essentially, she said that the note said that the jury didn't disagree necessarily on the evidence. They'd reviewed it all, but they had different opinions on what the evidence meant. That's what she said to the two lawyers in the courtroom, to the prosecution and the defense. And so then she asked how they would like to proceed. The prosecution, of course, Lolly said, they haven't had enough time to deliberate. We'd like them to deliberate more. They haven't had enough time to review the many weeks of evidence. And the defense said, we'd like you to issue the Tuey-Rodriguez instruction.
Mm-hmm.
That is the dynamite instruction.
That's the break glass case of emergency.
Correct. And so I'm going to actually play the tape of her reading the jury's note and issuing the instruction so that listeners can hear what the instruction says. But can I just quickly summarize my interpretation of it for you?
Yeah, go ahead.
It's essentially, it is your duty to come to a decision. It is the court's strong preference that you should come to a decision. You should not operate under the assumption that another jury will be smarter than you. You're it.
Right, okay.
So it is the state's, or in this case, the Commonwealth's, that's how Massachusetts refers to itself, obligation to prove beyond a reasonable doubt that the defendant is guilty. The evidence that you've looked at, you need to be convinced of it. Every single charge, every single aspect of every charge, you have to be convinced beyond a reasonable doubt in order to find the defendant guilty. If not, you must find the defendant not guilty. If you feel one way and other people feel another, don't be swayed just because you feel pressured. Because, so basically is like explaining how a jury is supposed to operate. It's like another jury instruction, but a much more stern jury instruction. Basically saying,
right.
You got to do it, folks. You got to do it. And here is what juries are supposed to do, really distilled down. There's an interesting bit in there about, strength of opinion. There's an interesting bit in there about, like, if you think that I'll just go ahead and play the tape so listeners can give it a listen. But first you're going to hear what the note said, and then you're going to hear the dynamite instruction.
All right. So, jurors, I am in receipt of your note. Judge Cannone, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. So, Mr. Foreman and members of the jury, I have an instruction for you. Our Constitution and laws provide that in a criminal case, the principal method for deciding questions of fact is the verdict of a jury. In most cases, and perhaps strictly speaking in all cases, absolute certainty cannot be attained, nor is it expected. The verdict to which each juror agrees must, of course, be his or her own verdict, the result of his or her own convictions, and not merely an acquiescence in the conclusions of the other jurors. Still, in order to bring 12 minds to a unanimous result, you must examine the issues you have to decide with candor and with a proper regard and respect for each other's opinions. You should consider that it is desirable that this case be decided. You have been selected in the same manner and from the same source as any future jury would be selected. There is no reason to suppose that this case will ever be submitted to 12 persons who are more intelligent, more impartial, or more competent to decide it than you are, or that more or clearer evidence will be produced at another trial. With all this in mind, it is your duty to decide this case if you can do so conscientiously. In order to make a decision more attainable, the law always imposes the burden of proof on the Commonwealth to establish every essential element of each indictment beyond a reasonable doubt. If you are left with a reasonable doubt as to any essential element of any indictment, then the defendant is entitled to the benefit of that doubt and must be found not guilty on that indictment. In conferring together, you ought to give proper respect to each other's opinions and listen with an open mind to each other's arguments. Where there is disagreement, those jurors who would find the defendant not guilty should consider whether the doubt in their own minds is a reasonable one, if it makes no impression upon the minds of the other jurors, who are equally honest and equally intelligent, who have heard the same evidence with the same attention, who have an equal desire to arrive at the truth, and who have taken the same oath as jurors. At the same time, those jurors who would find the defendant guilty ought seriously to ask themselves whether they may not reasonably doubt the correctness of their judgment if it is not shared by other members of the jury. They should ask themselves whether they should distrust the weight or sufficiency of the evidence if it has failed to convince the minds of their fellow jurors beyond a reasonable doubt. I will now ask you, Mr. Foreman, and members of the jury to return to your deliberations with these instructions in mind. And as with my final instructions and the supplemental instructions I sent in, I will send in a copy of this charge as well. All right, so may that be marked, Madam Court Reporter, please. All right, so thank you. We'll send you folks back out to deliberate.
All rise for the court, please. Jurors, follow me.
All right, so Kevin, they're back out deliberating again. Who knows?
Right. So they could come back again later today.
They could come back today. They could come back in days.
They could come back as soon as you finish editing this podcast.
That's right. And one thing that you should know is that reporters in the courtroom, if people are interested and they're not on Twitter, because, Twitter no longer lets you make lists anymore, so you can follow one specific story unless you pay for Twitter, which I don't. And I'm no longer verified because Twitter took that away from me, so I can no longer have some of the premium features. But there is a subreddit called Justice for Karen Reed. And I'm going to link to it again in our Crime Raiders on Facebook group. There's an excellent link there that has basically aggregated all of the journalism tweets from the courtroom. And if you sort it by newest, you can follow every journalist's observations from the courtroom. And that's how I knew the jury was coming back, by the way, because I was following this thread. So anyway, a bunch of the journalists said that when the jury came back in, there's one juror, juror number 7, who appeared to be openly crying.
And there was also, you said that 11 of the jurors walked in together and one on their own, and that was juror number 7 as well? Yeah,
that's what journalists said, but, I hesitate to, draw too much from that, but it was, in fact, the same juror, juror number 7.
Yeah.
The same juror, a couple journalists have said, has looked upset on other occasions, but again, we don't want to draw too much from that.
It certainly seems like that the state has not proven its case beyond a reasonable doubt to 12 people.
Nope.
Yeah. All right. So we'll see how this turns out.
Thanks, Kevin. Thanks so much for joining me on this edition of the Readathon. Talk to you soon.
Partners in Crime Media.